let's see here. Now, do I have a poll here? Maybe I should do one later, but I can do one now and later. Now, let's see. Let me launch this poll. You guys can answer yes or no. How many of you have a trust? That way it'll give us an idea maybe what to focus on. Oh, so 50-50.
I am. Sorry.
50-50, that's not bad.
No, it's not actually.
Yeah, that's not bad. That's impressive.
Hmm.
We'll have to do it at the end and see if that changes.
Maybe we can ask the question, are you going to get one at the end? I should say, as we're going along, Bob.
Can we?
Go ahead.
Can we guess who we think has a trust and who doesn't?
Okay, I do.
Oh, I do.
I do.
I can't vote, but I do.
Do
I
your
know
friends
that.
and family
I don't have one.
encourage them? Well, so I had a thought of talking about several different things since we have about an hour and a half, but I do want to encourage Bob to chime in because I suspect that he'll be able to provide some more depth or some perspective that this group might appreciate that I might not know. So glad you're here, Bob. I thought first I could go over basic estate planning basics. What are the elements and why might you want a trust or not want a trust? And what's the difference between revocable and irrevocable and that sort of thing. Some of it will probably be stuff many of you already know, but for those of you that don't have a trust and don't necessarily know why you might want one, hopefully it will be useful. Then other things I thought I would cover just generally were probate sales and trustee sales and how they work, particularly if the court is involved. And then separately, something that does seem to come up fairly often, Grandpa still owns the house. In fact, Grandma and Grandpa both still own the house on title, and grandson is now trying to sell it, and title's like, no, gotta fix that. It comes up surprisingly often. Oh, there's Tom. Hi.
How are you doing,
I'm
Ms.
great. It's so nice to see you.
Thank you.
So to go over estate planning basics, let's start with why you might want a trust. In California, if your estate, which basically means everything you own at the time that you die that is held in your name or jointly with a spouse or jointly with some other people, so you might own perhaps a percentage of something. So let's say, for example, in my case, I own half of this house that you can see. I own a couple of cars. Actually, I think there's 3 right now, kids. I own, with my husband, 50%. So 50% of this house, 50% of those cars, 50% of 2 retirement plans. There is no money left in the college fund, so that's gone. Various savings accounts, a couple of investments, the stuff in my house, the stuff in the house in New Hampshire. The house in New Hampshire is actually held in a separate trust because that's a family thing. Okay, so that's the stuff I own. So 50% of many things because I'm a married person. If all of that stuff, not accounting for debt associated with any of it, is worth more than $166,250, somebody's gonna have to probate my estate after I die. That's a really good way to make your surviving spouse or your kids really hate you. It's just a pain in the neck. So what does probating an estate mean? It means that somebody has to, if you left a will, post the original at the court, which costs $50 just for them to take it and store it and keep it as a public document. Then they have to file a petition to probate. That either means probate my will, which means do what the will says. Probate me without a will, which is called intestate. In the case of a will, they appoint someone called an executor. In the case of no will, they appoint someone called an administrator. It's just a term. The job is exactly the same otherwise. Then that person has to provide notice of the hearing to all the relatives who are required under the probate code. They have to publish 3 times in a newspaper that they are petitioning to probate your estate. That costs about $500 at a minimum if you do it the cheapest way in Fresno County. Then you have to have a hearing, and hopefully the judge says, yes, your papers are all in order and I will approve you. And hopefully no relatives says, no, wait, it should be me, the executor, not my cousin Steve. My granddad loved me better, or whatever, which sometimes happens. And then you have to do an inventory and an appraisal, which usually requires having the probate referee value quite a number of the assets in an estate. Anything that doesn't have a statement like a bank account or an IRA or something like that, the probate referee has to appraise it. They do drive-by appraisals, they do comparison stuff, they appraise the cars, they appraise the art, they appraise the antiques, they appraise the house, whatever stuff you have, and you have to list it all. Usually we do contents like household furniture, furnishings, and appliances, and the general rule there is if you had a yard sale and sold every bit of furniture, every pot in the kitchen, anything that could be sold that doesn't deserve to be thrown away instead of being sold, what would you make? Because most of us don't have super valuable stuff in our houses. If you have valuable art, if you have valuable antiques, that's different. But most of us have furniture that we've lived with for a while and the dog probably scratched it at least once or twice. So that's kind of how that works. Okay, once you have your inventory and appraisal, you are also in the, and sometimes you have to post a bond. If someone passes away and doesn't leave a will, then you're required to post a bond on behalf of the administrator that says, hey, if I screw up this job, there's an insurance policy in place that will pay the heirs what they should have had because I either mismanaged accidentally or I stole. Somebody goes to Timbuktu with the estate, and it does happen. And that's another expense. You have to qualify for it up front on your own credit as the administrator, and you have to pay for it up front. It's kind of like a homeowner's policy. You estimate replacement value and then you pay a premium that's lower, but it can still amount to a couple $1,000s out of your own pocket right up front. Okay. Then you are able to reimburse yourself from the estate if there's any cash, but you have to maybe wait for a while to be able to do that. At the same time that you're doing, once you get your bond posted and your letters are issued, then as you're getting everything appraised, you also need to be notifying any creditors that you know about. That's in large part what that publication was about too. But if you know that there are creditors out there, you actually have to send them a specific notice and say, hi, if the decedent does owe you some money, please get in touch with us. And then most of them will. Many of them don't wait around. They reach out right away. You also have to contact Social Security Administration. You have to notify Medi-Cal in case there was some Medi-Cal. You have to notify the VA if there's any benefits coming from there. You have to notify a variety of agencies that might be affected by the death of this person. Then you have to field any bills that come in that the decedent owed and decide whether they're legitimate bills. Some of them are not. Pay them if you can. And then once you get the estate so that all the bills are paid, you know who all the creditors are, you've figured out everything that you have, you've marshaled all the assets, then you come to the process of saying, okay, what does the will tell me I should do in terms of distributing this stuff? Maybe the will says, sell the house. I want you to only do cash gifts. Maybe the will doesn't say that, and you have to make a decision. Should we sell it or should we pass it down? Everybody gets a piece of it. How should we handle that? And if you don't have a will, then the probate code basically says, here's who the heirs are. It's generally your spouse, your children. If you don't have either of those, your own parents, your siblings, nieces and nephews, kind of works his way out like that. It's fairly obvious what would happen in any family. If you don't leave anyone, and we can't find anyone, then your estate escheats, they call it, to the state of California. So it's a good idea to leave a plan if you don't want it to go to California, but us taxpayers would probably appreciate it if you don't leave any family and don't have a plan. Then it goes in the general fund. So that's the process. It can often take a couple years, particularly if there are items that are difficult to appraise, if there are family members fighting, if there's a tenant in a house or a rental or anything like that that doesn't want to move, you might have to go through the eviction process, which right now would mean, okay, we can't do that. A whole variety of things can cause this to take a very long time. Sometimes you can get permission from the court, but you have to go ask for it, and you have to pay $435 to file the petition to do the asking. Every time you file, it's $435. You can ask to do an early distribution. So if you know, let's say I've got an estate of a couple of $1 million, we've got to sell a particular part of it, but I do have enough cash over in this other account here that I could do an early distribution of maybe $25 or $30 or $50,000 to the two kids. The court will often let you do that as long as they're confident that there's enough money left in the estate to pay any obligations the estate may owe, that kind of thing. So it depends on the size of the estate and how complicated it is as to how long that process can take. Many of them are very simple. Many of them are not. And when people start fighting, it gets a lot more expensive. On the plus side, what the executor and or administrator can do is hire an attorney like me or Bob to help you through that process. We know the forms, we know how to do the probate court stuff. The current judge in the probate department, Bob, back me up here, can be rather cranky. I actually
comment.
I recall she had a bailiff who served in her courtroom for a very long time, and first question out of your mouth when you check in with him is, does she have her grumpy pants on today or not? And he was always very nice about saying, yeah, stay under the radar if you can. One thing she is absolutely a stickler about is giving notice to everybody who's entitled to have it. So let's assume that one of my parents passes away. They're both in their mid-80s. It's going to happen probably in the next 10 years. I have to find every relative who's entitled to have notice. What if, and thank goodness this is not true, I don't know where my brother is. He went on a trip to Japan and we lost touch with him, and we don't know if he's dead or alive. He's somewhere in Asia. I am required to do everything in my power to hunt him down and give him notice that one of our parents has died and he's entitled to inherit. And that can be an incredibly tedious and expensive process, but you are required to make a Herculean effort to find heirs because they're entitled to receive what they're entitled to receive. That can slow things down. So that's generally the outline of the process. When you get everything, all your ducks in a row, you've got everything appraised, you've got everything valued, you've paid all the bills, you know exactly what you have, and then you file a petition with a final report. Here's everything I've done, and here's my plan to distribute the estate according to the will. So for example, if the will says, whatever my stuff is, divided equally between my 3 kids and pass it down, and it doesn't give any instructions, or it says in cash or in kind, perhaps what you do is the kids have decided we want to keep the house and rent it out. Okay, so then you have to say we're going to pass it down. Everybody gets a third. We divide all the other assets up in thirds and off they go. And your final, so the court will then review that, hopefully approve it, and then final jobs will be, you got to do a deed as the administrator of the estate. Everybody has to sign receipts that say, yes, I got my stuff. And then finally you can be discharged and you can let your bond go. So that's basically the probate process. Here's kind of the bad news. Trust administration is very similar, except you don't have to report to the court unless something goes wrong and somebody drags you in there. So one of the main reasons that we recommend as estate planning attorneys, and many financial planners will also recommend this, if you do a trust, you don't have to have the court supervise that entire process. Now keep in mind that most probate proceedings are not adversarial. Even though you're in the courtroom, the judge's job there is to make sure that you do that administration of the estate properly, that you marshal all the assets, you find everything you're supposed to have, you notify everybody who's entitled to have notice, you pay all the bills, you do that properly, and then you pass it down as directed by the will, if there is one, or by the probate code, if there isn't one. And so a lot of it's just checking the boxes and saying, hey, administrator or attorney for the administrator, have you filed your inventory and appraisal by the deadline I gave you? Have you posted your bond? Because we're not going to let you do anything until you do that, and so on and so forth. So they're just making sure for the protection of the heirs, basically, that you're doing your job properly. And the current judge in particular is like, let's get this done. And you can get yelled at if you're too slow. Again, Bob can vouch for me. Bob Oliver, who used to sit in that department, was a lot nicer about it. But if you were too slow, he'd make you bring the donuts on Fridays and show up on Friday to explain why you were going so slow. Also a little unpleasant. He wants to go to court on Fridays. So that's basically probate process, which is the fancy formal name for someone has passed. We got to figure out what that person owned and pass it on to whomever he or she directed, or in the absence of a will, to whom the probate code directs. The probate code basically assumes you want your stuff to go to your family. So if you have a plan, if you want to do some charitable giving, you need to plan for that and you need to write it down. There are very specific requirements for wills. They're not really all that difficult. They can be handwritten. We prefer that they not be, just because many people's handwriting is terrible. It's better if they contain certain kind of formalized language that helps us understand what you want to do. They need to be witnessed by two people in California, and there's certain specific language that needs to go in them that makes them what we call a self-proving will. It's a paragraph at the very end that both of the witnesses sign that says, I know who this person was. Doesn't mean I have to have known them for a long time, but they've introduced myself and I've seen their ID. They're telling me that this is their will, that they're doing this of their own free volition, that nobody's pressuring them, that this will says what they want to have happen with their stuff after they die. Then the court can be reasonably confident that two people have talked to the person who's signing the will and saying, this is my plan. And we can feel good that, okay, that's your will. We always want the newest one, obviously. We want them to contain language that says, hey, I'm doing one today and I'm revoking anything I did in the past. Or I'm writing a codicil, is the word, to say I want to add some language or make a change. An example of that might be that I wrote a will 20 years ago and I named my wife as my executor and I didn't name another person. Well, my wife has passed away now. So I need to do a codicil to say I want it to be my oldest child, and then if my oldest child isn't able to serve, then my next oldest child, that kind of thing. That's a common form of modification that we do all the time. So that's real basics on wills. Does anybody have any specific questions before I move on?
Catherine, in regards to trust, let's say husband and wife dies, in the trust, she has indicated, or they as together, co-trustees, has indicated that a piece of property go to a specific area, and let's say the husband is not fully on board. After the wife dies, doesn't the husband have 100% authority to change whatever the trust says, regardless of what the wife wanted?
That depends on the trust and how you write it. So let's
You mean
move
like
to
it's
trust.
revocable or irrevocable?
Well, okay, so when you write a trust, let me explain the reason why you want a trust. So if you don't want to do that probate process and you don't want the judge to be supervising you, write a trust.
Right.
And put your stuff in the trust. So the way that we typically put our stuff in the trust is that we put the big assets in the trust early on. Your house, if you own rentals. A lot of financial planners will tell you they also want your investment accounts, your retirement accounts, to the extent that you can, to be owned by the trust. So the way that the trust works is, the simplest way to think of this is like a file cabinet. Top drawer is the trust, the next drawer is the stuff that I own outside the trust. Maybe the third drawer would be stuff that I happen to be holding that belongs to other people, that I possess or control. You own things as the trustee, but it's simpler to say it's in the trust as opposed to I'm the trustee now, okay, now I'm just myself. Now I'm my trustee, now I'm just myself. It's a little confusing, but you act as your own trustee typically unless or until you can't. One of the big pluses besides avoiding probate about trusts is that they can work for you before you die. And that includes both spouses if you write one together, which we typically do. If you're a married person, you write a trust together. People who are not married can also write a trust together if they choose to, that we want to do a joint plan for our stuff. Okay? Brothers and sisters can do this. People who are partners but who are, for whatever reason, have chosen not to be married and not to register as domestic partners, all fine. You can do that if you want to, but it's not as common as otherwise. So what we typically do is we say, all right, let's transfer the big stuff into the trust. What we want to do is to make sure that when a person passes away, whatever is outside the trust that I own at the time that I die is worth less than that magic $166,200 number. So big assets go in the trust. We do wills typically that we call pour over wills that say, hey, anything that I own outside the trust. You might do those specific lists of, I want my granddad's watch to go to my grandson. Those few things, you can do those in the will, but generally what we do is we say, hey, anything I own that's not in the trust now, put it in the trust. The trust has my plan for how I want things distributed down the road, okay? So we have 2 wills, one for each spouse, flowing into this trust. Now to address Tom's question, typically what we do is we say, as Tom suggested, that both spouses will be co-trustees and will manage the property that's in their own trust. And the language basically says something along the lines of, while they're both still alive, this property shall be managed by the trustee or co-trustees, depending on what we have in place at any given time, for the benefit of those settlors, the people who wrote the trust, created it, and put their stuff in it. So typically the original trustee is also the settlor, the person who dumps the property into it. So in my case, that's my husband, Eric, and myself. In Tom's case, that's probably him and Angie, okay? So let's say you get to the point where the first spouse either passes away, and your question is passes away, or becomes unable to make decisions is also another one. Typically, we say the surviving spouse continues as his or her own trustee just for themselves. Now, if you own separate property that you put into the trust, it retains its character. So as an example, let's just use Tom and Angie. Let's say Tom came into the marriage and he owned a rental house, because Tom does rental houses, and that he inherited from his own family. So it belongs entirely to him. Angie's name is not on the title. He has not added her. But he decides to transfer that house into their joint trust. It's still his sole and separate property. It retains its character. Let's say Tom is the first one to go. Sorry, Tom. Tom's instructions about what will happen with that separate property in his portion of the trust stay in place. Angie can't control what happens to his separate property except to the extent that his instructions say Angie inherits it. So he could say, upon my death, that immediately goes to my daughter. He can do that. But typically the question would be, does the surviving spouse have the power to modify the trust with regard to everything that's both of ours, or that I now own as the sole surviving spouse? Most trusts do give that surviving spouse the power to modify, on the assumption that, I could croak tomorrow, and I'm not quite 60 yet, and my husband's younger than I am. So it seems a little bit unreasonable to say, hey, for the rest of your life, you can't change this plan that we made together. He might want to do that. But then again, there are times when maybe that's not so appropriate. And a lot of it really depends on the timing. Typically, however, once a person passes away, their particular instructions for my stuff, my separate things, that part becomes irrevocable, because you can't change something that I directed after I die if it's only my stuff, okay? When the second spouse passes away, the trust absolutely does become irrevocable. So any successor trustees at that point cannot change the plan that Eric and I made together, okay? So it is possible after the first spouse passes away that modifications can be made to the plan, but not after the second one does. Did I answer your question sufficiently, Tom?
Exactly. Although I will tell you that I'm surprised primarily because I've come across certain examples where a husband and wife have a trust, family trust, wife dies. The wife had indicated things that she wanted done, and now the husband is the surviving trustee. And as far as he's concerned, there's a new sheriff in town.
And the big difference would be, did they own that property together, or was it
They
something
did.
the wife owned entirely separately? You have
No.
more ability to control after you die stuff that you own as your separate
Mhm.
property, but stuff that we own together, not so much.
Well,
But
if I might, there is a provision that can be put into a trust that separates the community property so that the spouse that passed away, their interest in the community property goes into what we call a bypass trust.
Yeah, and that's the one. So it's how you plan what's just yours. So think about it this way. If we own it together and I don't draft my trust to say that my half stays over here, the spouse typically keeps all of it. So it's a question of how you draft your trust. So if you own something separately, you control it. And if you say my half of what we own together goes over here, then you have more ability to say, you don't get to change the rules after I go, Bob. Most trusts, however, are written that the spouse that survives inherits both shares of the community property. They already own their half, they get the other half. But it is not unheard of, particularly for second marriages, late in life marriages. We have relatives, kids from different relationships, that you will make those fancier arrangements to say, when I go, if I'm the first one, my half of this stuff goes to my side of the family, my children, your half then goes to them. Even in circumstances when we do that kind of planning, and again, please chime in here, Bob. Often what we will do is we will say, okay, second marriage, we both have a child from a previous relationship, and we don't have any children together, let's say. Simpler. The first spouse passes away. The trust assets are to continue to work for the surviving spouse for as long as he or she lives. But then after that person passes away, we're going to take what was my half of everything, and maybe I brought a whole bunch more into the marriage than you did. My stuff's going to go to my kid, and your stuff's going to go to your kid. So I'll continue to support Eric with whatever I left for as long as he survives. But then when I go, let's say I brought 3 of those rentals into the marriage and you only brought 1, and then we have the home we own together. So I have my half of that. My stuff all goes to my kid. So the nice thing about this is you can carve up that pie pretty much any way you want to. And that's also true in a will. And make a plan that works for everybody. But the nice thing about it is that you can say, okay, after I go, this document is still going to continue to work for our family unit, however it may be constituted. And we can kind of preserve how I came in, how I go out. Prenuptial agreements also do this. If the marriage falls apart, I came in with this batch of stuff, you came in with that batch of stuff, we leave with our same batch of stuff. However, it's changed, but that's my stuff over time. So absolutely, Tom, you can do that. It's just a question of the instructions that the trust gives to the trustee, okay?
So it sounds like you need 3 trusts. You need his trust, her trust, and the trust you have together for the things that you accumulate while you're married.
Actually, not necessarily. One trust document can do all of those things for you, and it can give instructions to say, and they often do, when the first spouse passes away, we're putting certain of his or her property into this bypass trust. So the trust document actually says when that first death happens, we're going to create a new trust over here. And we're going to push this property over here and manage it in this fashion, and then keep everything else back over here under the main trust document. There are some trust documents that have several new trusts created. A lot of the stuff that was done in terms of older trusts had to do with avoiding the taxes on the estate as well. Right. A standard term says we're going to defer the estate taxes that the first spouse who dies might owe on, let's say, her stuff until the second spouse dies. The tax code allowed for that. And then you wait until the second person dies, and then you pay both of your estate tax. The assumption being there that by the time the second spouse dies, you're going to have shrunk the size of the estate, the value of it, and there will be a smaller total tax owed. That was particularly important for a period of time when the minimum value of your estate to have to actually pay taxes on the estate, the death tax is the fun nickname for it, was pretty low. That hasn't been the case for, Bob, 15 years, something like that?
Bush.
Yeah, so now it's over 5 million. Most people don't have an estate over 5 million. So most estates, the average Joe, never pays a death tax. And the standard thinking is it's probably going to go away eventually. But the number is high enough that the average person isn't affected by it, even when you wait. Okay?
What federal ID should a trust have?
Federal ID, it gets its own tax number. You just go.
Well, as an example, I have a trust, it's my social security number. So in a sense, that trust is me, no matter what. So
After you pass away, you go pull or you can now, you can pull a separate tax ID number for it if your trust is earning its own income.
right.
Yeah, except it is you legally, it is you. So it's not a,
Kathy, I got a call from a realtor. Grandma passed away recently, had no will and a reverse mortgage. What experience have you had with a reverse mortgage?
Well, in particular, and Bob, you may have a lot to say about this, it really depends on the term of the mortgage deal. Sometimes what happens is whatever equity is left in the house goes to the mortgage company. Sometimes it's just whatever we've paid you, you owe us back. It really depends on the terms of the deal. But often what will happen is that basically once you sign that reverse mortgage, more commonly the lender is going to want to try to take the whole house, whatever's left, no matter how much we've actually paid out to you. But the more standard, that's the shadier side of that industry, if you will. But the more, or if somebody's been pulling money out for many, many years, it's effectively the same thing. But the more standard routine is, okay, now basically you've created a debt that you owe to the reverse lender on this particular piece of property, and we have the right to call it, basically.
Well, they'll get it paid back, but any leftover equity will be, goes to the heirs.
Yes.
if there's equity left, if there's equity in the property, the heirs have the opportunity to have an appraisal on the house and purchase that house at the lower of the amount owed on the reverse mortgage or the appraised value if it's
Or 95% of the appraised value.
Yeah, and you have to go look at the terms of the particular contract on that loan. The shadier side will say, oh no, we get to grab the whole thing. And there's unfortunately not as much control over that, or some of the older ones like that, or unfortunately people who,
Yeah,
shopping.
sorry, Counselor, actually, a lot of the older ones still have that clause in there. Since '89, there have been verbiage and so on where the heirs and so on are totally protected. If it's upside down, yeah, no worries, just give it away.
Exactly.
Well, even those older ones are probably protected by law that they can't enforce that clause.
Oh, good. Okay. Because I remember there being a lot of hullabaloo about it.
They're highly regulated now.
Now that's a
Extremely.
big help. And you do raise a good point. If the house is upside down, because the lender is taking a risk, Granny might live another 20 years. She doesn't look like she's gonna, but she does. And they end up actually paying out more than the equity is available in the house at the time that she actually passes away. The family is not on the hook for that upside.
Correct, but that's why the FHA insurance is there to cover for that. And or if the lender servicer goes out of business, so FHA will then appoint a lender in that situation.
Yep.
Okay.
So
Okay.
yeah.
I've done transactions for an estate that had a reverse mortgage, and the heirs were able to sell the home and keep the proceeds. I've done 2 of those, and the last one I think was maybe not 5 months, maybe a year ago. And they did have enough equity where the heirs were able to keep the proceeds from the sale.
If I may, probably the most important thing is if you run into that situation, you have a limited amount of time. So some of the lenders are more gracious in working with you, but it has to be resolved quickly.
Yes, I think they had like 6 months or something like that.
Just something to be aware of right now. It's taking 2 and 3 times as long as it normally does to get a death certificate out of the county. And you can't do a darn thing until you have that death certificate. So if it comes to your attention, go order it. And from what I understand, if you make an appointment to go down and pick it up, you'll get it faster.
Yeah, the sequence of events is you have to notify the servicer or lender within the 3 months of the passing of the loved one. And then you can either decide if you want to purchase it, then you have up to 1 year to decide to purchase it, or family says, hey, not interesting, sell it. And then then the servicer lender will then sell it, and then like Carmen and the other people, Mr. Abrams mentioned, then the proceeds then after pay off the expenses, etc., then go to heirs as it's stated in the trust.
Right, or whatever is owned. And if there is a trust, that's great. If there's not, you always end up reverting out to the probate code for who gets it if there is no other written instruction somehow.
Right, that's the situation right now for this with the grandma. Thank you very much for your input.
Well, I feel like other people knew more about that one than I did. So thanks, Bob, and you, and Carmen. The one thing to be mindful of is deadlines. In all of those, family members tend to let things go. It's either they're really anxious to do it tomorrow, and you're like, well, we can't make it happen that fast, or they just kind of, oh, I'll deal with it tomorrow. Oh, next week, I'm busy, you know. And you do have to, one of the biggest jobs sometimes that I have is to say, no, this can't wait, or there's going to be a penalty, or your family's going to lose something. And it's not unheard of that a family needs to sell a residence that grandpa left or dad left, and he still owes a mortgage, and they just don't pay it. And they end up losing it because it's 6, 8, 9 months goes by and bank gets tired of it. And I'm like, the probate process is doing what it's doing, but I can't make it go any faster. You know, we have to wait the 120 days for the creditor's claims. You guys have certain jobs you have to do. If you're going to get it on the market, you know, you got to, maybe sometimes you have to go ask the court's permission to sell it. Come on, we got to get it done. And if you're not making the mortgage payments or even the homeowners association payments, hello, they won't wait forever. They don't have to.
Another little issue on that is if the person that qualifies for the reverse mortgage or their spouse, excuse me, no longer lives in the house, if they go to a convalescent home or something like that, the clock starts ticking. You're supposed to report it to the servicer immediately, and that 3 month,
And
6 month, 1 year, depending on the age of the mortgage starts ticking. So they call the loan if they're no longer eligible for it. So
to the extent that you have the ability, make sure that your clients know reverse mortgages can be a wonderful tool for your elderly relatives to live on the equity that they have accumulated without straining other family resources. But by the same token, they do have very strict terms. And if you don't abide by them, you can end up losing equity that you shouldn't have to lose just through inaction, because 6 months can go by faster than you think it does. So that's one of the best things that we can offer people a lot of the time, is just to say, watch the calendar, make sure you know the rules. When I was working as a realtor, and I think I've told this to Bob and to Tom in the past, the thing that astounded me most was you couldn't get people to read the dang contract.
Right.
They would not take the time to do it. They were not interested in the important terms. And of course, I'm like, oh my God, no, I'm a lawyer. You have to read this. And they're like, nah, we trust you. And I mean, people get angry. So that's it. I almost got to the point of saying, here's the checklist. This is the stuff you got to know out of that 8 or 12 or whatever pages it is of mice type. These are the 5 things you have to know about this contract. Sometimes I would do that. It sort of helped. And that would definitely be a thing to do for reverse mortgages as well. But whenever somebody passes away, the passing of time is something that you want to go, hi, hey, are you sure you're on top of this? Even if it's just your next door neighbor, because it can really cost people things that they don't realize they're going to lose, put it that way.
You know, Catherine, in the state of California, it's not required that an attorney be part of a real estate transaction. Now, this is the largest, in most cases, investment that that family makes in their entire life. Nobody advises that client on how they should take vesting. Nobody.
They don't. No, they don't. And that's a very good point. So you all, I'm sure, know the basics, the basic options for taking title. Tenants in common, where you each own your share and it passes down. Joint tenancy, where the last man standing wins.
Right.
Community property, husband and wife. Community property, where a community property state. That joint tenancy thing is you know, it's the poor man's, lazy man's way of making sure that whichever one of the surviving spouses is the survivor gets to keep the house. And an awful lot of families will add my son, so it automatically goes to him. And, you know, that's the cheap and dirty and easy way to make sure that, okay, the house goes to my kid. It's easy if you only have one kid. It can be a little harder if you've got three and the other two are kind of mad at, you know, John over here. Capital gains does play in sometimes. It depends, but, you know, there can be tax consequences, but it is the cheap and dirty way to pass property down. Absolutely. One thing that we recommend when a married couple is owning property together is we want it to say community, husband and wife as community property with the right of survivorship. So that way you've got the community property designation if there's divorce. You've got the basically the joint tenancy protection that the surviving spouse automatically owns 100% of it when the first one dies. So that's something, but you have to tell your title officer that that's what we want, or they'll just do joint tenants or husband and wife, and they won't do anything more because they don't know to. It can be really important.
You know, Catherine, I
often-
notice doctors, attorneys always take the title that way.
Because somebody told them to,
Yeah.
like me. Did somebody
Right.
else do something?
How often do you recommend to review your trust or will?
Some people say every 10 years is a good idea, or if some major life event happens. So for example, if you have a trust and one of the two of you passes away, you need to go back in and say to either the person who wrote it for you or some new person if that person's no longer available. What do I need to do? One of the things you have to do is record a document that says there's been a change of trustee, because instead of co-trustees, now there's just one. And you have to record that so that if you decide to sell the house that's in the trust, the title company's not looking for your wife to sign. Well, she can't, you know, so you have to do that formal notice. So if you have a new child, or your children have all now emancipated, big events like that, if you get divorced, that brings up an important point. And I'm sure that Bob has run into this as well. When you file for divorce, you are not allowed to change the trust. You are not allowed to change the beneficiaries on your life insurance, on your retirement, or anything like that, but you can write a new will. So typically when you have a trust, you also have those pour over wills I talked about. Well, you can say, I no longer want to have my plan for my stuff to be tied up with this person that I'm divorcing, that I don't like anymore. So you write a new will that says anything that's not held by that trust, I have a new plan for it. And we do recommend that you do that pretty promptly after you file for dissolution, because people do die before judgment is entered. And if you die before judgment is entered, you are still married.
Yeah.
It happened this last week to me.
One thing if you have people going through divorces, is they can't, what they can do is sever joint tenant.
Yes, that
I'll
also.
call you back. I'm on Zoom right now.
Oh, I'm sorry.
That's okay.
So yes, that's another very important point. If you hold title with someone that you are now divorcing as joint tenancy, you want to sever that, which is basically a document that says this is converting to tenants in common. So now I can walk away with my percentage and you walk away with your percentage, but if one of us passes away, you don't get to own it all. So, and that benefits both parties in a dissolution, because typically you don't want to stay with the plan. That's not universally true. I do have people who have divorced who said, no, we don't want to change any of it. We don't want to be married, but we're still friends and we still have children together and we don't want to make those changes. We're fine. So it does happen.
You know, Catherine, a lot of, well, I do know some folks that say they don't enter into a trust or do a trust because the spouses oftentimes can't agree on who's going to take care of the children. Do you see that a lot?
Well, actually, a trust does not dictate who's going to take care of the children. But yeah, that is a reason why sometimes people get really, really worried and bent out of shape. So the other thing I do in my life is family law, which when you run into me and sometimes I'm grumpy, that's usually why. Carmen's gotten to do a couple sales for me in divorces. It's been super fun. Sometimes it's not. So how does that play in? Okay, if one spouse dies, the other spouse is automatically still the parent of those children and the kids stay with that parent. Guardianship only comes up when neither parent is available to care for the children. That could be because you've got a little bit of a habit with heroin, you're incarcerated for an extended period of time, whatever it may be, and somebody's got to be able to obtain medical care and register the kids for school and all that kind of thing. If one of the parents is still alive and able and willing, that's it. We don't talk about it any further. But if both of them, you can nominate a guardian. And sometimes parents don't nominate the same person, and they do have a difference of opinion about that. And it's usually because I really don't like your sister, or I really don't like her husband. I want mine, and vice versa. You'd be surprised how many people don't ask, hey, will you take care of the kids if we go? Surprise. Always ask. In any case, what ends up happening is that ultimately the people who are left after you're both gone or unable duke that out in the probate court is where guardianships happen. So if there's competition in the family about who's going to take care of the children, there's a judge that has to decide that, because a judge has to be the one to appoint the guardian. There is a petition that has to happen. Sometimes it flows through the juvenile dependency court, but more often it happens in the probate court with a petition to appoint a guardian. So at the end of the day, people who are in big disagreement about that, you should write down what you want. I prefer this, I prefer that. But at the end of the day, after you're both not able, those people are going to have to decide what's going to happen. And they may agree, I'm sorry, we can't. We can't take that many, our work schedule doesn't allow. You guys take them, we'll help support, whatever, whatever it might be. So if you run into people that are saying, well, we're really fighting about that, I would say, gosh, don't let that be the thing that prevents you. Write something down that says, we do have a bit of a difference of opinion. These are the two families or the two family members or the people that we would like to see look after our children. But that's only a recommendation or a nomination. It is not what absolutely happens.
Kathy, alternatively, they could refer one of the spouses to you and one of them to me so we could handle the dissolution.
Yeah, if you really can't agree about who should take care of your kids, you probably shouldn't be married anymore. Where that gets really awkward and people get really scared is somebody's having an affair and the other spouse doesn't know about it, and the spouse with the affair is nominating my girlfriend. Ultimately, it doesn't have a whole lot of force. Somebody's got to come into the probate court and say, will you please appoint me as these children's guardian? And if you're not a relative, you have less of a shot at it than someone who is a relative. The courts prefer that kind of stability for the children. Because at the end of the day, appointing a guardian is all about what's in the best interest of the children. We don't really care what y'all wanted. You're gone, sorry. So that's ultimately the way that it works. And I am in the middle of one of the biggest guardianship fights I have ever seen. It's really fun when the kids are also Native American, because it's not only what the two parents wanted, who are now both dead, so what their two families want, but the tribe has something to say too. So we have three fighting. It's fun.
Catherine, we as investors, what is the best way to protect the trust from liability from investments we have that ultimately falls under the umbrella of the trust?
Well, it depends on the source of the liability, really. I would say, first of all, insure it, insure it, insure it. And that would include business interruption insurance, depending on the nature of the assets that are held in the trust. So in the case of many of your investors group, obviously, given that this is a real estate investors group, we're probably talking about rental properties or commercial property that are being held in trusts. Right. You can, and again, Bob, you have so much experience here, you might be more useful than me. I tend to do a lot of personal family trusts, that kind of thing, smaller scale than what many of you do or what many of your clients do. But you can certainly create a separate entity. That can often be a really, really useful way to go. And then the trust owns the shares of perhaps a corporation. So the trust owns the business entity, but you have a business entity that is kind of a layer below the trust, if you will. So that the trust is getting the benefits, but doesn't necessarily, if the business entity is worthless, owes debts and so on, the trust assets are not at risk. Right. So you want to create layers is the biggest way I would put that. you want to be sure you have a very specific business plan and that you've organized things that way. But what you're looking at, though, I think is, I don't want to ultimately lose my personal residence if my other assets go completely south, correct?
So, yeah, a trust does not protect your assets. A trust is only a means of conveying assets and avoiding property, unless it's an irrevocable trust. In California, there are some trusts outside of California that may be provided. But remember, when you hold assets in a trust, it's you. They're still you. They're not, it is not, even though it gives the facade of a separate entity, but it's really legally not a separate entity until you die.
Mm-hmm.
So if you do something personally that you have liability for, and it's in excess of your insurance or the asset that's at stake, every asset in that trust is available for a judgment.
Mm-hmm.
Yeah,
Yeah.
and you could also name your trust in your umbrella. So you can call your insurance, whoever you have your insurance through, and have your trust named. I know with farmers you can do that.
Yeah.
So that could also help.
It's real important. In fact, that's an important point. Some insurance companies will cover you anyway, but if you have the insurance in your personal name and the property is held in the trust, some insurance companies won't provide coverage.
Yeah, you want to make sure that you're asking that question. For instance, a lot of things are being excluded now, and you should be getting letters if that's happening on any of your policies. Like, for example, dog bites are almost 100% excluded now from landlord policies. And we just got a huge memo about that at Farmers Insurance, really having us reach out to our clients and letting them know to have their renters get renters insurance. And there's a lot of that going on right now to be able to minimize the risk. So our co-insurance carriers are coming back to us and saying, hey, getting more and more losses in California, things are costing a lot more money. And this is an area that for us to give you co-insurance, you need to start excluding these things. Farmers has done really good at debating that and finding co-insurance through carriers that will allow us to do that. But please don't assume anything, because very quickly it can all be swiped away.
Yeah. And it's absolutely true that, there are some things that when you're doing rental properties, whether it's commercial or residential, you really got to make sure that your tenants have some coverage too, because you can end up really holding the bag for incredibly irresponsible or criminal stuff that they do that affects neighbors, other tenants. So that kind of thing, it's, paying attention is a really important part of it. Sitting down with your agent and making sure that they know, your insurance agent, here's how I hold title. Here's how I'm doing things. How can I be sure that I'm safe? That, and keeping eyes on the prize. It's astounding how often people will end up in my office saying, well, I just didn't know. I'm like, well, did you check? Did you call them? Did you drop by and have a look-see? I was talking to somebody just the other day that made a deal with a tenant that said she was an interior designer or something like that. Well, I'll pay you to remodel it and we'll make a deal. And she basically demolished the kitchen, both the bathrooms and one of the bedrooms, and then never fixed it. And she's like trying to say, it's uninhabitable and I don't owe you any rent. And he's like, wait, what? And I'm like, well, how long has this been going on? Oh, about 15 months. Really? And you never dropped by? You never said, wow, this is taking too long? So that's another place where people just don't follow up. And I'm like, well, okay, I'll pick up the pieces as best I can, but there's some things I can't solve for you. And of course, right now, everything is taking 2 and 3 times as long, even if you can evict where you are. In many places you cannot. I believe that the order in California actually expired on September 1st.
No, they extended it to.
It did extend it? Okay, yeah. And of course, then the feds are saying we're extending it too. So that's going to affect an awful lot of people, unfortunately.
There are other ways with it. Tom, to just add a little bit on protecting an asset, if you have a high income producing property that is also potentially high liability, like a shopping center or something, you could put that asset into an LLC or a corporation with the trust owning the stock or being the sole member. But you want to make sure that you treat that as a business and not as a piggy bank, because if you do, they might be able to get through the corporate veil and get the assets anyway. But that would be an additional shield that you could do if you have a property that meets that criteria. But it would just be too expensive to do it on every property or on a rental house or something like that.
Yeah, and that's what I was trying to say at the outset is you may want to create an LLC or some other entity, and you would want to, you know, talk with whomever advises you on your business ventures there. That you might want to own all of those. If you've got one big asset, that might make sense. But if you have several smaller residential rentals, you might also want to create the same sort of an entity to own title to those 5 or 6 houses, because collectively, then you can end up, you know, in a problem, if you will. But as Bob says, yes, you have to follow those rules of corporate governance and management to the letter, and you have to run it like a business, and your trust maybe receives profits or distributions once or twice a year, but it can't be, I just use that checkbook whenever I want to. In order to maintain that corporate separation and preventing going upstairs, that's critically important. And a lot of people are very careless about that too.
Well, you know, I've said many times that we as investors need an investor team, if you will. And one of the most important individuals in that team is your lawyer. And as an example, I've got a few rentals, and unfortunately, I'm not practicing what I preach, merely because not only, in my opinion, each investment need its own LLC. So you got more than one LLC hanging out there. And each LLC hanging out there on its own that funnels into the trust. But obviously this is something that your lawyer is going to have to advise you on, because the last thing I want to have happen is to have a problem at one of my rentals and I'll lose my house on Van Ness. And it can happen because it's all part of the same trust.
Yeah, that's absolutely true.
To what Kevin was saying, I have properties in different with different insurance companies, you know, because certain insurance companies won't take certain properties, that kind of thing. So I have probably 3 different insurance companies for, you know, various properties, and I have umbrella policies, I think, with all of them to a certain extent.
Well, you know, Carmen, I'm kind of a lazy individual to begin with. And so what I did, all of my insurance is with one insurance broker. And that broker will broker those policies wherever that policy needs to go. But that agent is my risk manager. Mm-hmm. She fixes me a binder every year with every insurance policy I have, including my cars, my houses, my investments. And we go over those every year, and she'll broker those out to where they need to be. Like you say, if you're dealing with the larger companies might say, I'm not writing anything at 93711. They've had a lot of automobile accidents out there, so we're not covering that zip code right now. But if you've got everything with one broker and make her or him your risk manager on every piece of insurance you have. Mm-hmm. And that's worked out very well with me. Anything that comes in under the title of insurance, I send it to her.
I actually have to recommend that, and I think Bob would probably agree with me there. And part of the reason that I say that is my husband does a lot of insurance coverage work, litigation. They will fight with each other over who has to pay what part of it. And so if you've got 3 or 4 different companies with pieces of potential liability, that can be really problematic for you, because none of them wants to have to pay out if there is a claim, and they will try to push it off onto the others. Whereas if you've got an integrated plan where your agent knows these are all the pieces and I need to be covered for all of them, and here's how I own them, that will keep you safer if you ultimately do have to make a claim, because as Eric's granddad was very fond of saying, insurance companies are not in the business of giving money away,
Right.
period. So I would suggest you pick the one that gives you the best customer service and go sit down with that person and say, here's my world, how can you cover it? And then, obviously shop it, but I would do that. I think Tom's approach is much, much safer.
Yeah,
Well, I'm sorry, go ahead, Bob.
I was just gonna say, if you have a broker like Tom does, they might place coverage with different companies depending on the
Right.
property,
Yes.
but their umbrella will cover all those properties. If you go to an individual insurer like State Farm or Farmers or one of those, and you insure some of your properties with one and some of them with another, and you get an umbrella policy with one of them, the likelihood is they won't cover, that umbrella will not cover the other properties. So you have to be real careful.
Yeah.
Right.
Even
Well,
though the odds of making a claim regarding all of them are relatively small, you want that, when you buy it, you want the guy who's selling it to you to be fitting all those pieces together for you, not you piecemealing it and hoping for the best.
Well, what happened, I think, was at one point, the company that I used wouldn't take a certain, more than a certain number. And then I had to go on to a different company.
Then I would take them all to the other company. I wouldn't.
Exactly.
Mhm.
Well, I can guarantee you one of the best decisions that I made was putting all our insurance with that one broker. And I only talked to one person. Much to my dismay, I've got about 20 policies that come due on the same day every year. I don't care. I don't care.
Yeah, but that is painful.
I just write the check out and go on to the next thing. But anything that transpires goes through that insurance broker first. I mean, obviously me, and then I give it to my insurance broker and it's handled. So you might consider, let these large companies do what let these large companies deal with the individual that's got his home and his car, fine. But we as investors, we need additional protection, and you need someone that's well-versed in insurance to protect you. And I'd go, and anyone interested in knowing who I use, contact me and I'll tell you who it is. And I've never regretted that decision.
I think that's probably the best advice you're going to get in this entire discussion today. That's really, really good advice.
Yeah, feel free to unmute yourselves if you have any questions.
Hi, Angie.
Good morning.
Oh, hi, Angie.
How are you guys?
Nice to see you.
You too.
First, Catherine, also legal advice. We always need a legal beagle on our team. So
Well,
that's the other
I
tools that we need.
I appreciate that very much. And, you all know where to, well, hopefully you all know where to find me. I'm at Borton Petrini now. But
Like you're at home.
yeah, myself. Bob knows where I am. Tom knows where I am. Carmen knows where I am. You can always hunt me down. And you're welcome to call my cell. You don't have to call my office. That's always happy to answer questions or to point you in the right direction if I can't. Just to lay a cap on Tom's last thing is he mentioned he has one broker for absolutely everything. That includes his personal residence and his cars. And you do get some bundling benefits. That's one big check every year, but at least it's less than it would be if you had 17 different ones to write to different trips, because they do give you those benefits. So
I agree.
the other thing is that if you're really working with one person and you're working at probably the guy that or woman that Tom works with, they work with this kind of a customer, they're going to be able to offer you advice about how to cover and how much coverage to maintain that you and I might not know. That's their business. That's what they're good at. So let them help you, because that's how they get the business. And customer service, of course, is huge as well. So that can be really, really, really important. A couple of other little things I did want to just throw out there and see if they matter. I can do some more estate planning basics, but I think you guys are all pretty sophisticated. I would just say, if you don't have a trust and you have stuff that's worth more than that $166,200, please do get yourself a trust. Your kids will thank you. Your spouse will thank you. Life is a lot easier if you don't have to go to the probate court after somebody passes away. Couple of little things on probate sales. Just show of hands, how many of you have done a sale where you actually have to go into the court and get the sale approved? Not very many. It doesn't happen all that often, but it does happen.
Sure.
The one thing I would say, and I'm sure you all understand that, the disclosure requirements are less when it's a probate sale, same as when it's a trustee sale. And one thing I have found with real estate agents, not this group, but many, many, many agents still do not understand that probably a quarter of the people in Fresno County own their residence in a trust. And many, many, many of their sales or their purchases are either coming out of a personal trust or going into one. And they get really, they don't know that they need their people to sign contracts, trustee, to be sure that they're naming the trust properly in the contract documents. That can be a real problem when you get to escrow. And title officers are like, hair is being ripped out, really frustrated. So to the extent that you can educate your colleagues about, it's just a different form of owning it. Again, it's not Kathy and Eric Amador owning the trust, it's Kathy and Eric trustees owning our trust. Or you do the hat, it's an easy way to think of it, but an awful lot of people don't get that distinction, and then you have messed up contract documents, or you have deeds that have to go back and be corrected, and so on and so forth. So really, really important for realtors representing either buyers or sellers. One of your first questions is, do you own the house in a trust? Do you want to put the house you're about to buy into a trust? Do you have one? And people just don't seem to ask it. And there's a million other questions. I understand it's not necessarily top of mind, but it does need to be. If you do have the rare circumstance where the executor of a will or the administrator of a trust that is being supervised by the probate court does not have what we call independent administration of estates authority. You have full authority, you can buy and sell property on behalf of the estate without having to go back to the court. But every once in a while you run into one that you have to get the judge's approval. It's going to add a month, sometimes 2 or 3 to the process, because once you are under contract, you have to be under contract first, then you have to petition the court for approval. In some cases, you can do that on what we call an ex parte basis, which means it can happen in less than 30 days, but it is often the case that it is going to take more like 45. And that's only if you have all your ducks in a row and do all your paperwork properly. And I have actually twice seen people bidding in the courtroom. It does happen. And there's a very specific process by which the next bid has to go up. And you have to calculate what that additional bid amount has to be each time. And it's kind of like a sale at the courthouse, the other courthouse on the steps. You got to be prepared to do it right now. So it's kind of interesting, but the judge will hold an auction. It's a rare day that you see it. And right now, probably less than otherwise, because they're really not wanting to let people into the building, but you can go, if there is one, you can go into the probate court. Masks are required in the building, and they won't let you take them off.
Talk about a nail biter. I was doing an exchange a couple years ago, and the properties that I had identified, one was a traditional sale, one was a probate, and one was a short sale. And I was thinking, oh my gosh, I have to buy 2 out of those 3 properties, right? Mm-hmm. And it so happened the short sale and probate, came first. But on the probate, it was a nail biter sitting there, just, wishing no one is going to bid on your property. That was interesting.
Usually people don't. People tend not to follow that.
I think there were people there to bid, but I think we were already at good numbers.
Good, that helps.
Yeah.
That helps. And it is a little weird going to court now. We lost Bob. Most hearings are happening on Zoom now.
Yeah.
And just FYI for folk out there, at least in Fresno County, all the courts are operating, but there are absolutely no trials or contested hearings other than domestic violence and other emergency type matters on the civil side until January at the earliest. Criminal courts are up and running. Juvenile dependency is up and running. They are doing contested hearings, but they are not doing them on the civil side.
Well, yeah, DVs are
yeah, except DVs, emergency type stuff. So yeah, I have a cousin in Chicago who is a state's attorney there who's doing criminal trials on Zoom. And I'm like, well, okay, show me how. So we'll see. It's in case it comes up. Everything is slowed down. So try to avoid needing to use the courts. God forbid it should come up for any other reason, because they're just stuck. They can't. And the biggest problem for them is that there's no staff. They're having to double up staff, and it's very difficult. So and it's not the same in every county. Santa Clara appears to be entirely shut down. Tulare business as usual. So it's county by county depending on where you're doing things.
Yeah, there's one of the Bay Area counties is doing trials by Zoom, civil trials.
Alameda is. They won't let you in the building at all.
Even jury, they did a jury trial by Zoom
Yeah,
as well.
it's crazy. Yeah, and I don't know how. Well, basically, it's like my son's tutoring algebra on his whiteboard. So anyway, couple of other things that I popped up with, or I would like to make sure that people understand. Trust administration is another topic that probably most people don't run into until somebody says, hey, dad died and you're number one on the list of successors. Congratulations. I'm really glad it's not me. I'm the one stuck with it in my family. Everybody's surprised, I'm sure. Both my brother and sister are out of state, and my husband said, I'm not doing it. You do it. So it works very much like doing the stuff in front of the court, except you don't have to do it in front of the court. No one's looking over your shoulder. But as the successor trustee, whether you're the surviving spouse, or more importantly, when you're the person picking up after both initial trustees or settlers have passed away, we call it administration. And there's a reason for that. It's because it's kind of like an administrative job. Think of it as being, a very, very small town city administrator or something like that. So you have the same basic set of jobs. First of all, you have to notify all the beneficiaries and other interested persons that there's been a change of management. That often requires recording a document that's a fairly simple one with a death certificate that says, hi, there's a new sheriff in town. So that anybody out there knows I'm the person who is now authorized to sign deeds or other things like that. Trusts can range from the simplest of documents and organizational structures, if you will, to very complicated. People do use trusts, of course, to own very, very large and complicated assets, a variety of assets, operating businesses, all kinds of things, or it's just my house. And the latter is the more common one for more and more families, but, and we do encourage people to do them as long as they get along, and to avoid probate, which is not necessarily, but sometimes it's good to have the judge involved, honestly. So first thing to say about that is, if there is a disagreement, or if the trustee is not doing his or her job, other beneficiaries always have the option to do a petition to the probate court and say, hey, Your Honor, this trustee is screwing up, and I want you to boss him around or take him out of his office or whatever it is that might need to happen. Most commonly, it is that they have not provided any sort of information to the other beneficiaries about what I've been doing in my official capacity as trustee, how I'm managing things, what assets are out there, how's money being spent, what's going on. And if you're a beneficiary, it's the same as being an heir under a will. And so if the person who's managing all that isn't telling you what's going on, and they're not automatically being required to report to the court, as you would be if it was a regular probate, you can understand how people would be like, well, hey, what's happening with mom's house? It's been 18 months and you're still living there, and I know it's all paid off. Hello? And it happens a lot. People think, oh, I don't have to report to you. I'm the one in charge. That's not true. Now, trust documents will usually say you don't have to account except at the very end, or you don't have to account unless this or that or the next thing. But the probate code says if somebody asks you to, you got to do it, even if the trust doesn't require you to do it voluntarily, if you will. So you always have to answer to the other beneficiaries if you're being the trustee, but you'll probably run into circumstances where you're representing the trustee who is perhaps selling an asset that's in the trust, perhaps mom's house, but they're not communicating with other siblings or something like that, and you get a phone call going, hey, you're working with my brother Tom, but he's not telling us anything and I want to know. As the realtor, you've been hired by the trustee. Technically, you don't have any obligation to tell beneficiaries to a trust that you've probably never seen. So your job will be to go back to the trustee and to say, so people are calling me. That's not my place unless you tell me that I can give information out, but you should know that you have an obligation to keep those people informed. And if you're not sure about that, you should go talk to an attorney about what your responsibilities are that way. If most people obviously do operate in good faith, but the biggest problem is that they think that they don't have to tell people. And they also tend to maybe pay themselves a little too much for doing the job of managing mom or dad's trust. You're allowed to reasonable fees. Many counties have in their local rules what we consider to be reasonable fees. It's usually about 1% of total trust value, unless you're doing extraordinarily extra work. Obviously, you are entitled to pay the realtor that you hire to sell a house from trust assets. You can hire accountants. You can hire an appraiser to do. We've got an art collection here. I don't know what that's worth. You should have it appraised. But the job is a very basic one. Okay, mom or dad has passed. You file or record the appropriate notices. You marshal the assets. That means you got to figure out, what did mom and dad own? How did they own it, and what's it worth? And you create an inventory that has each of those values assigned with it. That may mean you need to hire an appraiser, or it may mean that you call a couple of realtors and say, hey, can you give me a number and get it in, okay, then I have a reasonable, I take the average. That's probably what the house is worth. It's very likely, and it's cheaper. It depends on the size of the assets and whether or not you expect somebody to be challenging you. If you're expecting a challenge, you should probably go pay a licensed appraiser. Always worth it. So once you've got everything appraised, you're often in the same job that the executor would have been in, which is you got to pay all the bills. There's the final hospital bill, there's the funeral expenses that, whatever may come up, you may be reimbursing people for stuff they did out of pocket, that kind of thing. It's often yourself. Got to be careful about reimbursing yourself. Make sure you have receipts and all of that kind of thing, just in case somebody questions you. People get really funny about money. And there's also Lenore Schreiber puts it beautifully, whoever got that really ugly green ceramic frog cookie jar that was on mom's kitchen counter, well, she loved that kid best. And they'll fight over stupid stuff. So if you're serving in that capacity, do make sure that you can document what you did, where you spent money, and why, to whom you paid it. Be careful about hiring family members. Sometimes that can be awkward, unless you let everybody know, hey, Joe here is the guy who's going to fix mom and dad's house. We all know him. He's our cousin. We trust him. He's reliable. Don't just, don't be silly that way. Once you've established what you have, you've paid all the bills, you've verified that we know what the estate is now, the trust estate. The trust is going to tell you how it shall be distributed. And it's often going to give you deadlines to do that. First I want you to give $5,000 to each of the grandchildren. Then I want you to divide up whatever's left between all of the kids, but I want my youngest daughter to be able to stay in the house for at least 10 years. That might mean that I have to stay on the job for 10 years. There's a whole variety of things that can happen, but most of the time you want to wrap up trust administration like you would wrap up a will. And a year should be more than enough in most circumstances. You tend to run into problems when people drag things out. I don't remember what I did, or I didn't think I had, or the house is still sitting there, and and maybe it's been empty and it's losing value because how an empty house gets, and things are breaking, and who knows. So if you're involved with somebody who's serving as a trustee, or if you happen to be doing one because it's your own family, try to make sure that you finish that job like you would finish maybe a remodel job. Try to, it's going to take longer than you think it should. It's not going to come in on time, right, Bob? But you need an end date in sight. You need to accomplish it because you want to be able to use that darn kitchen. So that's important. But the other jobs are basically the same. You don't have to publish notice, but you do have to make sure that any creditors who are entitled to it know that your person has passed away. You have to make sure that all the appropriate agencies are notified if they're receiving benefits of any kind, or they might owe some. If your grandmother was in a nursing home and she was receiving Medi-Cal, That's the other really, really important reason to have a trust. If your grandmother is in a nursing home on Medi-Cal, that can be hundreds of thousands of dollars depending on.
Want to do it today? Oh, okay.
And they will come after the house if the house is not in a trust. If the house is in a trust, they'll say, oh, our condolences. Bye.
Oh, Catherine, you did a case that was, one of my friends had a young daughter. So when you have a trust and you're the trustee for her estate, because obviously the parents were divorced, so now you have underage children, you're the trustee of that estate. When they're 18, then that child takes care of that. I think it was 18 in that particular case. Some, can go up to 24 if it's in the trust that, they have to go to school and there's a particular amount they can get from the trust in specific years. Are those more common than not?
It's very common. In fact, when you write a trust, you'd be committing malpractice if you don't include some language that says, if a beneficiary is not an adult, meaning they're not 18 yet, then we have to, people who are minors cannot take title to property. So you might say, well, the car belongs to my son. No, he can't own the car by himself until he turns 18. So a classic example might be that a parent dies young, and they left a will and they're divorced, as you say, and I want my child to have my house or the value of my house. The child cannot take title to the house. So one of two things has to happen. If you're dealing with a trust, you can say, hey, trustee, keep that house or sell it and keep the money for the benefit of the child. And as trustee, you can continue to do that. And the trust may instruct you to create a 529 plan or to set up a UTMA, Uniform Gift to Minors account, that kind of thing, which is a trustee sort of an account. Then the trustee can stay in place until that child turns 18, or the trust might say until the child turns 25. Some trusts don't allow you to distribute to a child until they turn 35. Or they even can say, yeah, that kid's got some nasty friends and some drug habits. So trustee, you're going to hang on to that money and you're going to dole it out as you see fit. And that might be for the life of the child. There are also, and wills can do that too, I might add. Wills can say, you can't distribute it until the person turns 18. They can say, don't distribute it until they turn 35. And there are a variety of vehicles that can hold money for that. But you don't necessarily want to give an inheritance to somebody just as they turn 18. That tends to result in Ferrari purchases and no college tuition, which is, stupid. So what is typically the case is that you will say, trustees, stay in place and use this money for their education, their medical needs, their general support, and so on. And you stay on the job and you manage that money in a trust account for the benefit of that child. If you don't have something set up like that, and it is often the case that wills don't provide for that, or somebody passes away and leaves life insurance to their child, you have to create a guardianship of the estate and appoint a guardian to manage that property for the child. If it's cash, the probate court will require you to put it in a blocked account, and you have to get a court order to pull any of it out. You can set those up so that the court order says automatically, $1,000 a month can come out of that blocked account that you can use for the child's needs. But typically in a circumstance like that, if a child loses a parent, they're also going to be eligible for Social Security benefits. So the expectation on the part of the probate court is going to be that you use those Social Security benefits, which last until this child is 18, to pay for their month-to-month needs, and you keep whatever that inheritance is in the bank against their young adult future. So there are a variety of tools, but the bottom line is that you can't pass money or property on to a child, and you can create lots of restrictions or leave another person in place to manage that money into the future for as long as is necessary. There's also, y'all should be aware of, there's a thing called a special needs trust. I don't know if any of you have heard of that. So let's say in your family you have a child who's developmentally disabled and is never going to be able to manage their own money, and they do qualify for Social Security, disability income, SSI money, or and they may also qualify for Medi-Cal or CVRC benefits, or someone in your family has, or a client or whoever, has been in an accident or something, and they have a settlement coming from, the insurance company or something like that. And a classic example would be, the car accident. You are now in a wheelchair. You have health issues that you never would have had but for that accident. We don't want that settlement to get blown on medical bills that you shouldn't have had to pay in the first place. There's a thing called a special needs trust that is designed specifically to capture money either from an inheritance or funded by other family means or from that sort of a settlement that cannot be in the injured or developmentally disabled person's name. You have to have a trustee, and it can't be spent in a way that you endanger what we call their public benefits. We want them to keep receiving that Social Security. We want them to be able to stay on Medi-Cal, but we've got money set up in a trust over here with a trustee who knows the rules for that, and they are complicated. So I can pay for medical stuff that Medi-Cal won't pay for. I can pay your rent, but I can't give you cash. I can't have money in your name. There's a lot of pretty tricky rules about how those have to be managed to avoid losing those public benefits. But that is another thing that you can set up in a trust to say, when I die and I'm no longer able to help support my disabled family member, my money will flow into, that's part of my estate plan. It's called a testamentary trust, where you say, part of what I want to do when I go is to create a special needs trust for my kid. And you can write that directly into your trust or your estate plan. It can be, or you can write them because a settlement is coming in to capture that money. Sometimes they have to be supervised by the court and sometimes they don't. Guardianships of the estate do have to be, and you do have to provide accountings on a biannual basis every other year. Sometimes every year, it depends on the circumstances. So it's a pain in the neck, but it's a great way to protect somebody who has special needs. So.
And Catherine, for those that may need one, do you have like a checklist of what you should write down or need in order to start your trust?
Sure. We have a questionnaire. I imagine Bob has one too. That basic questions are going to be, I need to know who all your family members are and what your relationships are and past relationships were. If you were married previously or whatever the heck else, who are your kids? Tell me about your family. Then it's tell me about what you own and how you own it. And then tell me what you want me to do with it for you. When I do an estate plan, I also include powers of attorney. And I know that Bob certainly does this too. And there are two kinds of powers of attorney. There are for healthcare, we call it an advanced healthcare directive. And this is where you give instructions for whomever's going to handle medical decisions for you when you cannot do it. They can come into play and out and in and out. Think of the circumstance where you're in a car accident, you're unconscious for a few days, or so loopy because of whatever they're giving you that you can't make decisions. Your person makes decisions and then you come out of it and you take over management again. There's also the durable power of attorney to manage your stuff outside of the trust. So your basic banking, paying my bills, talking to PG&E for me, and so on and so forth. That one, again, it can come into play when you direct somebody to do things for you or you're not able to. You may be able to come back into management. And for many of us, there comes a point in our life where, okay, I can't anymore, and this becomes a permanent arrangement. You're acting on my behalf. In the healthcare side, I try to write them so that there's never going to be a need for a conservatorship. You can't perfectly guarantee that, but we try to write them to say, I want to stay, as you're making medical decisions for me, you are also empowered to make decisions about where I will live and how I will have my daily needs met. So if I need to hire a housekeeper or I need to hire a caregiver, you have the authority to do that for me if I'm not able to do it for myself. I always write them to say, if the person wants this, I want to stay in my own home for as long as I can safely do that. And that might mean that you do need to hire caregivers for me and make those arrangements, and you're entitled to do that. That may mean you need to work with another person who has the durable power of attorney to manage my funds, my assets. Often it'll be the same person. But we try to do that so that there's no need to go to the court to say, hi, my mom can't stay in her house anymore and I don't have the authority to move her. I don't have the authority to sign a lease for her. We want to be able to do that. If the person who gave the powers of attorney is not willing to cooperate with those efforts, sometimes you do still have to go to the court. Even though you've written all, I want this, you have the authority to hire that. every once in a while, and the one I think of most often is I had a couple who were late in life, second marriage. They both had children from former relationships. Fortunately, they all got along really well. Both mom and dad started sinking into Alzheimer's on about the same timing there, and they would not allow anyone else in the house. They were convinced that everyone that their kids tried to hire to help, even their own kids, were stealing. They were convinced that they could handle everything. They were both in walkers, but they were swearing they were vacuuming and mopping. And ultimately, we had to conserve them because they simply would not allow their family to take care of them, even with all those powers of attorney. You know, it sometimes happens that way, but usually it doesn't. So if you do them ahead of time and you give people enough power to say, if I'm in that state, you can do whatever needs doing, but I do want to be able to stay home as long as I can, it can really help. The other thing that I do write into them, and I think that this is really important, is to say, regardless where I'm living or what arrangements you make for me, I want to remain socialized. Because the worst thing you can do is to have Granny at home with a lovely person who's taking really, really good care of her, but barely speaks any English and gives her no intellectual stimulation. So it's Granny and the TV, and whoever calls her once in a while, especially nowadays when nobody can visit. That can be really hard on people. So you need to anticipate those kinds of needs too.
And I know of people that are business people, and they say, well, I've instructed in my, I don't know, will or trust that I am to remain in my home until I die, you know, because they have the means to remain in their home and they don't want their children putting them out of their home.
Yeah.
You see that a lot too?
When I write them, I say you shouldn't be quite that absolute, because that might mean that your children basically have to set up a mini hospital in your house. And that's cost prohibitive. Even if you can afford it, it's kind of a waste of money. Particularly if you're past the point of really knowing who you are or what you're doing or any of that kind of thing. So I try to say, give the person that you are giving authority some discretion to make appropriate decisions for you when you're past the point of being able to make them for yourself. It is also really important, and Tom, you raised this question. Let's say you have that business set up to manage your rental business. You need to have a plan for when you're no longer part of the team, because you could have a stroke tomorrow. You know, you might be 35 and have a stroke tomorrow. And if you don't have a plan and nobody else is authorized to sign checks, holy crud, you know, the court doesn't operate that fast. You can't get somebody else to fix that for you right now.
And also let your spouse know where all your stuff is, where you
and your passwords.
Yes.
And your passwords. Don't make it easy in case a burglar decides to look for your passwords. And do also make sure that if you have an estate plan or that business continuation plan and your insurance policies, that somebody else has a copy and or at least knows where to find them and that they're stored safely. When I write an estate plan, my firm keeps a copy, but I don't have the originals. I can give you copies, but I won't have the originals. Somebody needs to know where those are. And I actually also recommend to people to set up the binder. And Tom, you probably have one of these. I know my dad does. Who's my insurance agent? You know, here's my PG&E password. Here's all the accounts I have. Here's the gardener's name, all that kind of stuff. So that if somebody else has to take over quickly, they know who to call and where to go.
Right.
The classic example of this is if any of you ever got tagged, probably you gents didn't, to run the elementary school carnival back when your kids were little. Somebody's got a binder that says where to go get the hay bales and who to order the hot dogs from and, you know, who's the guy with the bounce house and all that. You need the binder with the phone numbers and the names. It really helps. So I always suggest, and as people are moving into a home, it's a good time to do that. Get this figured out, you know, and if you're selling a home, give them the one that you're on the way out. This is the person who fixes our pool. This is you know, and then you know to go do one for your new home. It's really a good tool for a lot of people. If somebody else has to come in all of a sudden, it can be a lifesaver. So.
Hey, Catherine, I'm going to jump in the last second. I know we're getting towards the end. I wanted to circle back around and remind everybody, Catherine, I think we have you booked for a Tuesday morning at the MLS here at the end of September. And
yes.
I want to circle back around. Is this going to be the same topic you want to address then? Because I think this is phenomenal, by the way.
It's entirely up to you. And I have the 29th, right?
Yes, that's correct.
Okay. And it's at 8:30?
9 o'clock.
9 o'clock. Okay. Yes. But if you, what I would suggest is by all means, ask your folks if they have specific questions, and I can be a little bit more, this group, you know, has a little bit more experience with some of this stuff. I can be a little bit more basic elements, if you like.
We can start an email string on this. I'd prefer to go with topics that you want, and then we'll promote. It's going to be a popular meeting no matter what you want to talk about, Catherine.
Yeah, they love me. They know me.
They
love
do.
me.
Oh, they do. It's absolutely. They're already lined up for the 29th. So anyway, we'll circle back around after this meeting at a different time. But I really appreciate you this morning.
Yeah, but by all means, please encourage people to either to send me questions. I would really prefer to be sure that I nail things that people want. And if we find that we talked for half an hour about this, but people have 10 more questions about that, we can always do it again.
And I don't think that, you know, with the topics that you talked about today, I mean, we can go on indefinitely because there's always a question that, you know, we may not have answered. But if you have any questions, feel free to unmute yourselves.
Yeah, there's always that, okay, I have this oddball situation. Stuff like that comes up in every probate, every trust administration. There's always something that you're like, wait, what do I do with this? Mm-hmm. Like, for example, you can abandon property that's in an estate or a trust that is costing you more than it's worth. You can just say, we're sorry, we're not going to keep it. Send that car off to the dump or whatever it is. You can do that. It's perfectly okay. But you have to be able to, you know, document it appropriately or you can get in trouble later. So all kinds of stuff like that. So let's definitely encourage people to ask questions because I do want to be sure that I'm as helpful as I can be.
We'll start that out. Thank you so much.
Absolutely. And I'll send you the questionnaire that we have for estate planning so you can share that with people because that shows what we need to know if we're going to build one for you.
Yeah, email it to me. That would be great. I can share.
Okay. Yeah, absolutely. All right. Anybody else have any questions? Nope. Okay.
Well, thank you for coming, Catherine. Really appreciate that.
Absolutely.
Let's remember on September 11, we will have Todd Dictos here, CPA and our county assessor. And he will discuss Prop 15, hopefully 19 as well. And I don't know if you read his article in the Business Journal. It was very good.
I didn't. I'll go look for it.
I'll send it to you. It's very good.
Oh, good. Thank you. I would appreciate that. Okay.
Anything else, Tom?
Oh, no. Well, the Apartment Owners Association is sending out they're flooding the market with this no on 21. And I think we all support no on 21. And this Proposition 21 is where the state would like to include single family residence and condo under rent control. See, right now it's not. So they're saying no on 21. I got mine yesterday. And, you know, there's still this, let's see, the city of Fresno is still offering more money to help renters and owners. And I think we as investors too have a certain obligation to communicate with our tenants and help whenever it's necessary. The end result is going to be the same, but in fact, I had one of my tenants in yesterday to communicate with her. I want to know, are you having any problems? Is there any way that I can help you? I want to know. So anyway, just words of wisdom, communicate with your tenant. Remember they'd pay if they had the money or you would have never rented to them to begin with. So anyway, thank you, Catherine. It's always a delight.
It's nice to see you too. I'm glad to see you. Last time I bumped into you, I'm trying to remember. It's been just months.
It's been a long time.
Yeah. So
yeah.
Anyway, all right. Well, hang in there. Nice to see you.
And we'll see you on the 29th as well.
Great. I'll look forward to it. Thanks so much.
Okay, take care, everybody. Bye.
Bye-bye.